Good afternoon, everybody. We're the Cannabis Legal Group. I'm Nicholas Galendez.
Travis Copenhagen.
Welcome to episode 82 of Cannabis Live. Today we're going to be talking to you a little bit about the gray market as far as how that's kind of transitioning from black to gray to legal cannabis industry as well as hemp and CBD. First, we kind of just wanted to give you a few little bit of updates on the news lately. There was another product recall issued earlier this morning that affected one facility out of Ypsilanti. As we've mentioned before, Laura is going to continue to release these. There's going to be growing pains throughout the industry where new growers are getting used to testing and those different types of kind of criteria that need to be tested for. So
yeah, I think we'll continue to see quite a few of those as the industry starts stabilizing. As the testing labs get up to speed on running those tests, and growers and processors start working on putting those products together.
Mm-hmm. And so other than that, there was another article that kind of circled around the news realm about opting out for Prop 1. So for adult use, what we had, I think previously was 60 municipalities that opted out. The new updated number for that is well over 250. And I think that, not to say that that's going to be what the climate's going to be throughout the next year and in the future, but it's definitely, certain people are worried that people are going to be too prohibitionist. There's going to be too many dry counties, dry municipalities for adult use, and as we're seeing too for medical. What are your thoughts about that?
And as we mentioned in previous videos, it's kind of predictable that most of these municipalities are going to just kind of opt out, kind of take a lay of the land, see what these rules and regulations are going to be over the next several months as they develop. And remember, any ordinance that gets passed can be equally undone by passing a new ordinance. So it's quite predictably reaction to these municipalities not wanting to feel bombarded by potential businesses they're not prepared for. It's probably unnecessary, as we mentioned too, because it doesn't matter if you're silent or not, you need an ordinance to basically allow these businesses to exist. So if we continue to see it, don't let that discourage you too much. It's an opportunity to engage in that municipality with discussion if it's a municipality you're interested in, and continue to encourage to educate these local officials to learn more about the law, how it works, and I think we'll see opportunities created in some of these places that have opted out recently.
Mm-hmm. And I also think too, the next step after that doesn't work, after you've talked to your council person, township board member, there's really no movement there. Remember that Prop 1 does allow for ballot initiatives to be done at the local level to opt into either medical or recreational. Depending on how that's drafted, there could be different types of legal challenges, but there's certainly an avenue for the people to get that enacted if and when their elected officials don't budge, despite the evidence to the contrary that there should be.
Right, and they can't prevent local consumption. Like, they can't prevent you from growing your own plants, from having possession, consuming. They can't prevent businesses from traveling through municipalities. So all they really can do is prevent licensing opportunity on parcels in their jurisdiction, and we'll continue to see that be a topic of conversation. Mm-hmm. So,
and then I guess the last bit of news, it had kind of made the rounds last week, but there was a lawsuit filed against the state of Michigan and the Board of Pharmacy, kind of as it relates to Prop 1 and the realities in Michigan. Just kind of a quick overview. Schedule 1 means no medical benefit, high level of addiction. And obviously in Michigan and countless other states, we have that medical marijuana acts and allowing that for medical use. So what this lawsuit does, and it was filed by John Sinclair, the infamous John Sinclair, and a few individuals against the Board of Pharmacy in the state, was basically asking them and saying that, to acknowledge that this is something that should be done. The Board of Pharmacy is responsible for scheduling the different types of drugs, and it still remains Schedule 1, certainly at the federal level, but also at the state level. And that was kind of symbolic of a request of forcing them to actually take action and say otherwise.
Right, so just like under federal law, under our Controlled Substances Act, marijuana is currently listed as a Schedule 1 substance. The Michigan version of that lists it there as well. And the intent behind this lawsuit, as I understand it, is to recognize that we've had medical marijuana in Michigan for over a decade now, and making our laws actually line up with the intents and purposes of other laws in the system. So
I think it's interesting too, just that the lawsuit named the Board of Pharmacy director Nicole Cover, who is also on the licensing board, and so just kind of a little bit more context for the lawsuit. It is on the one hand you have somebody sitting on the board licensing this activity, and the person that's sitting on that same board for pharmacy is saying that it's still a Schedule 1 substance. So we'll see what movement that
it's certainly one to watch, and we'll definitely be watching it and reporting back on it as it develops. So.
So yeah, that's all with the news and updates for the week.
Awesome.
Travis, if you want to kind of lead us into our main topic for the day.
Yeah, so as I'm sure several of you who watch our show know, we continue to see news articles about different individuals and businesses trying to fill a gap, trying to engage in providing marijuana to people who are interested in getting it for non-medical purposes. We hear businesses, buy a product, receive the gift of marijuana. We see businesses infusing marijuana into food and beverages. We see groups of individuals finding a place where they can socially gather to consume marijuana. And we just wanted to kind of walk through what we're going to refer to as a gray market. But effectively, like when you change any law, we're in a transition period. So we had, marijuana was illegal for most individuals in Michigan until we voted for this law in November. It went into effect in December, and we're now in a moment where marijuana is legal, but we don't have all the tools and processes available for that industry to be fully fleshed out and stabilized. So in that gray market, we'd like to just kind of walk through what our marijuana laws say, how they appreciate and impact businesses that want to engage in uses involving marijuana, and talk about where those limitations are so that we can ensure that we all understand how marijuana is going to be presented to us, especially from a commercial aspect.
And just to kind of lay the scene, there's the MMMA, Michigan Medical Marijuana Act, that was the patient caregiver model. That regulated very specific, small, type of group of people, which is patients with chronic and debilitating conditions and those caregivers, adults over 21 without a felony, that agreed to help them. And that solely touched that type of activity by those specific classes of individuals. Fast forward a few years later with the MMFLA, that's regulating licensed medical marijuana commercial businesses that also regulates the conduct of those businesses, not people anymore. And so as we kind of put those different hats on, the rules and the law apply differently to each one of those different hats. And so it's the same thing with Prop 1 with the RTMA as far as what the purposes of it are, what's allowed, what's not allowed, what kinds of things you can do with or without a license.
Exactly, and just like under our medical context, we had a transition, in 2008 when we passed the patient caregiver laws in Michigan, there was never a commercial aspect. And one of the biggest flaws over the following decade was, there's a need for a commercial aspect, but there was no law to support a commercial aspect. We had storefronts and dispensaries in some cities that would be completely illegal in others. It's led to and continues to be the cause of a lot of problems we have now in our transition as we're trying to roll out the medical licensing system. And we're going to see a similar thing occur under adult use, and that's kind of what we're going to march through. And as Nick said, to start, what we have is the Regulation and Taxation of Marijuana Act, the MRTMA. That law basically does three big things. It legalizes marijuana for adults, people who are 21 or up, to use. It legalizes industrial hemp under state law, and it creates a commercial system of licenses, rules, and regulations for businesses to engage in marijuana use as well. Those are the three pillars of what the law was designed to do. In medical, we have two completely separate laws, one for individuals, the 2008 Medical Marijuana Act, and one for businesses, the Medical Marijuana Facilities Licensing Act. The RTMA, one law, but still has two different tracks, one for what individuals can do and one for what businesses can do. And it's important to understand how that law impacts you if you are a business or an individual. So for example, there's language in Section 5 about if I wanted to give a gift of marijuana to Nick. I'm an individual.
Thanks, Travis.
You're welcome. What I grow is not very good, so you might want to find someone else. But effectively, as an individual, I can engage in the act of giving Nick a gift of marijuana, or vice versa. We're both adults. We're both more than 21 years of age. And if we were to do something outside the rules and limitations of that, we can only have up to 2.5 ounces of marijuana. If I give him a gift of 3 ounces, I've violated that rule, and there's a penalty associated with that. If I give him 3 pounds of marijuana, there's a bigger penalty. And it's all under the context of what an individual is supposed to do or not do. So individuals can cultivate up to 12 plants, they can consume marijuana, they can share marijuana, and there's penalties for staying outside of the lines. Now, a lot of people take that concept and think, okay, I can give a gift. Why can't I start a business that can give a gift? I can consume marijuana. Can I start the equivalent of a business where a group of us consume marijuana together? And the RTMA provides context for engaging a business in those activities, but it's not the same as what you or I get to do as individuals, right?
And really, you'll see this happening throughout the law and the different distinctions it makes. Same thing with Citizens United and corporate taxes. You know, a person, an entity is considered a person for certain purposes. As I mentioned before, you know, when you're an individual, you have that hat on. If you're an individual who's an adult, that's considered a different hat. If you're an individual adult who's a caregiver, that's also a different hat. And so the problem with that is that when you try to have a hat on and say you're one thing, but really, for all intents and purposes, what you're really doing is, you know, what's really applicable to that other hat, that other category, and that's where you run into issues that could be considered being in the gray area, could be considered testing the laws, stepping over the boundaries of the laws, which would, you know, expose you to liability and exposure for breaking those laws and regulations.
So there's two important concepts to really track, and it's going to make it very easy to determine what you can and can't be doing. You know, the first is the idea of whether or not you're an individual or acting as a business. And the second is the concept of what's public, right? So an individual giving a gift of marijuana, or if I'm cooking a dinner infused with marijuana and I happen to invite Nick over. As individuals, we can legally do that. And that went into effect December 6, 2018 when the RTMA went into effect. But if I were to be a caterer and have a business where one of the services I provide is providing food products that are infused with marijuana, I'm no longer an individual. I am now providing a commercial service. And what's really important to understand is the way we legalized marijuana for businesses was through a system of control. Businesses need to obtain the appropriate license to engage in services, and that license, you know, effectively regulates the business that you're engaging in. You're subject to those regulations, you're subject to taxes, and you're subject to the limitations. Now, the law is flexible enough to create new licenses, but until those licenses are defined, created, and a business obtains it, to engage in that conduct without a license is not legalized under the RTMA.
And we've had people ask, you know, what if I set up weddings and set up a bud bar at a wedding, and I do it in Colorado, I've done it in California,
Right.
You know, I want to do that here. And it's not to say that you can't yet, but the way that it's being rolled out, it was a ballot initiative. And so what usually that means is that it's a skeleton version of the law, and the rules have to fill the rest of that in. The other question is whether or not the law gives the agency or whoever is responsible for that the actual authority to create those new licenses. And for the RTMA, it does. It says that Laura can create whatever other kinds of license types it wishes to. There's some provisions in there about public kind of social use similar to beer, casino tents at a street fair. But those things all still have to be created in order for you to operate, to do that kind of bud bar at a wedding. Social use, as Travis mentioned too.
So as we evaluate the law, we do have a law that provides a path to engage in pretty much any type of business conduct you can think of if the state of Michigan is willing to create the appropriate license type. But that doesn't mean all those business uses are available today. What happened when the law went into effect in December 6th is the state of Michigan had to define the rules and regulations and provide license applications for a set of licenses first. Those licenses are growing licenses, processor licenses, safety compliance facilities, secure transporters, marijuana retail licenses, and microbusinesses. Now, they have to start with those first because in order for the commercial industry to exist, it has to start somewhere. Now, they have a year to put those regulations together and start accepting applications. Why do they have a year? Those regulations need to work. They need to make sense so that we meet the goals of the law. Those goals are consumer safety, security of facilities, preventing diversion into black markets, preventing marijuana from finding itself in the hands of children. And it'd be great if those rules and regulations came out faster, but in order for them to be effective, in order for them to make sense for these businesses to thrive in the regulated industry, in order for the state of Michigan to be able to police, control, tax these businesses, in order for third parties who aren't stakeholders in the marijuana industry to be comfortable enough to allow this in the compromise of how this law came to be, these are the compromises we made for businesses. So in the course of 2019, LARA, by and through the Bureau of Marijuana Regulation, will create rules and regulations. Those rules and regulations might not be perfect. Remember, the state of Michigan is doing this for the first time. But until those rules and regulations are in place, until applications are created, and until businesses have an opportunity to seek licensure under those applications, engaging in commercial adult use marijuana conduct as a business is not currently allowed. And that doesn't mean it won't be, and that doesn't mean any of us want it to take any longer than it has to. But we all need to appreciate that there's a process, and that's just how the law works.
And I was just going to say, whether it's fairly or unfairly, I think if they rush through with regulations, they'd be criticized. I'm talking about Laura here in the Bureau. If they rush through with rules in the application process, they'd be criticized for doing that and not taking the time to do it. If they took a long time to really flesh out 100% of what they want to see the industry look like in 5 years from now, they'd also get criticized for taking too long. So I think it's kind of, cut them a little break, realize that even though we do have these developed application processes and different ones for different categories, we have different rules fleshed out depending on investors or management companies, and then a whole thick set of rules and regulations applicable to every single license type and every single different category and different type of scenario. That's going to come. But what they did is they looked at all these different states and found out what would work at a minimum for Michigan, and now it's kind of just, it's an ongoing process, just like step one, it never ends. The rules are going to continue to get tweaked. There's going to continue to be advisory bulletins to move towards that fleshed out rule set. I think if you look at the rules 5 years from now, it's going to be significantly
it'll be more
dense.
nuanced. It'll be tailored to the needs of our state, and it'll be tailored to any unforeseen issues that get solved through that process. And again, the state of Michigan in the RTMA itself has that first year to focus on those first set of license types, the ones that are very similar to the medical marijuana versions. After that year is up, they are now free to create potential licensing systems for any other type of marijuana conduct you can think of, really. Social consumption licenses, sure, they can do that. They just have to get the first set out first. And whether we agree with priority or not, that's just the way the law was drafted and presented to the voters in Michigan, and they're running through the process of implementing it now.
So let's get a little bit more into these gray markets that we're seeing popping up. I know you had mentioned gifts. We can also talk about infused food and beverages and a little bit more about social clubs.
Yeah, definitely.
So I guess the first one I think that has been making the rounds a little bit more is gifting.
Buy a t-shirt.
Been some chocolates, there's been some books, there's been some other different business plans and strategies that have been kind of proposed, at least going around on the websites and in the news. I guess we should first talk about what's a gift, what's not a gift, what's a donation, and what the actual law says regarding that.
Right. So, and spoiler alert, regardless of how creative you are, if you are providing remuneration and receiving marijuana, it's going to be hard pressed to say that's not a gift.
Well, what's remuneration?
So being paid effectively.
Getting some kind, it's not a payment, it's not an exchange. It's basically, I think it's more broad than that. I think it's receiving any kind of value in exchange for something you gave.
Right. And it might be non-cash value. It could be a trade of services or a forgiveness of debt or something along those lines. So again, and trust us, this isn't black and white. There are ways that we can conceptually think of strategy to implement where cannabis is part of a transaction that might be surviving legal challenge. You might be allowed to engage in some of this as an individual, right? Now what's very clear though is if you're engaged in a commercial activity, that's most likely going to require a license. So if I wanted to give Nick cannabis as a gift and he also was buying a book off of me, then conceptually we might be able to engage in a cash transaction where he receives book and cannabis and I haven't violated the law. That's going to potentially, depending on how egregious that transaction is, be a factual situation that might need to be evaluated in court. If the value of the book is $10 and he pays me $50 for a book and some cannabis, we might have a problem. Now, maybe the widget we're trading has value above and beyond what the market says. I mean, there's ways to think about a transaction that involves cannabis, cash, and some other element that may or may not be legal for an individual.
And I guess too, this argument or excuse has been fleshed out before. I mean, I don't think if somebody were to get caught for doing this and not prosecuted potentially or potentially prosecuted, but they would say, oh no, it wasn't a gift, it was this. Right. I mean, that excuse has been used for ages. And I think the fact that if you plan on doing something like this and have to have a conversation with an attorney or just anyone who reads a certain section in the RTMA that says you can't do this and you're talking about what a legal gift is, I think that's already overstepping where that some conduct is not allowed, yet you're still trying to find that end around to somehow make it work and make it be legal. Right. And that discussion itself is just...
But let's move on. So regardless of how you've structured it, the RTMA is pretty clear. you cannot promote the fact that you're giving the marijuana away. So even if you weren't seeking payment for it, if you're a business and you're promoting the fact that buy a book, receive a free gift of marijuana, that is right in the language of the RTMA prohibited. Whether you're an individual, I mean, under the context of being an individual, but the mere fact of promotion that you're giving marijuana away is prohibited by the RTMA. So whether or not a business is selling books or chocolates or coffee mugs, you know, and they're informing their potential consumers, you should buy my coffee mug, you should buy my t-shirt, I'm going to be giving you marijuana if you do so, that in and of itself is promotion of the gift, promotion of the transfer, and it's not allowed. So, you know, you can be as creative as you want, you can play around with the definition of gift, it's all really for naught because the law is pretty clear about the promotion aspect of it alone. So if I just happen to be delivering pizzas, working for a pizza place, and I drop a pizza off with Nick, and out of the goodness of my heart, give him a bag of weed, no one promoted that. He surprisingly received it. That's probably not something you're going to be penalized for under a criminal context. But the business itself might not necessarily appreciate the fact that you did that because, you know, again, a business has a different set of concerns than an individual would.
And as far as that goes, why don't we want people necessarily giving away marijuana they've grown to anyone on the street? Like, what is the reasoning behind that?
Well, the easiest way to think about it is let's pretend we're not marijuana attorneys. Let's pretend I make brownies, not infused brownies, just straight up baked good brownie, right? What happens if I, in a business context or not, give Nick a brownie and he winds up in the hospital for food poisoning?
I'm going to sue you.
I'm going to be sued
for poisoning,
or potentially, you know, create damage, right? And marijuana is very safe compared to other, you know, substances people consume. We all appreciate that, but it doesn't matter if it's lettuce, tomatoes, brownies. It can be clothing. Like there could be all kinds of consumer protection elements involved with the transfer of a product to a consumer, regardless of what that product is. And just like in other industries, there's safeguards and protections for the consumer. Those same ideas and concepts are being applied to marijuana. And I think we can all agree, probably to an excessive amount because of what the plant is, but we are still in a situation of transition. You know, we take a product that's been illegal for like over 100 years and now turn it on and make it legal. We, as advocates, you know, want it to be treated as a tomato as soon as possible, but it's going to be a path and progress to get there. And part of the compromise we've agreed to in Prop 1 in the RTMA is commercial enterprises are going to be regulated, and they're going to be regulated to ensure consumer safety, and they're going to be taxed and licensed. And in attempting to have your business engage in that conduct without having that business be subject to evaluation is going to create a problem for you. The size and scope of that problem are it's drastically reduced in a Prop 1 world. You know, now, you know, to engage in what is considered an improper transfer of marijuana for a commercial purpose is a misdemeanor, but it's one that needs to be habitual, willful, and commercial, or for a commercial purpose in order to even rise past the civil infraction level into a misdemeanor. But it's still a misdemeanor. It's still going to be coming with fines. It's probably going to prevent that business from seeking licensure in the future. You know, and it could create ripple effects for other elements of what that business is doing. So, you know, in order to do this in a long-term successful way, unfortunately, as we wait for these regulations to come out, it's going to require a lot of these businesses to be patient. And nobody wants this to take any longer than it has to. And as cannabis advocates, we all want it to happen yesterday. But, you know, this is just one sector of Michigan's economy. And it's going to be treated the same way every other sector of the economy is treated. You know, in regulated industries, regulations need to exist to control them, and we've determined this is a regulated industry.
And I think so too, just about the giving away and advertising and promoting, and we can kind of move on to infused food and beverages. But the way you think about it, if I'm giving away an edible that I made at my house, I don't have to, I should probably, but I don't have to label that there's been peanuts in there or any kind of allergens and things like that. Right. So if I'm just giving him a brownie, and I don't advertise it, and somebody else comes over that he knows, maybe a group of friends, and they are having these brownies and I don't know about those allergies, I could potentially give someone something that could kill them. And so the regulations, and that's an extreme example, but that's just another reason why, you know, this isn't just allowed to happen, you know, as a free-for-all, and there's definitely some restrictions, especially when you're not advertising and promoting it. I think the idea for the health, safety, and welfare is that there's fewer people that could potentially, in a worst-case scenario, be subject to certain things that they didn't want to have introduced into their bodies. And
Exactly.
you know, the kind of a buyer beware demeanor as if you're getting a gift from somebody or getting it from your friend, but it's different when, you know, Joe on the corner block says, hey, I'm selling, or I'm taking donations and gifts for this. You don't know where that came from. You don't know all that. So
right, and that's kind of even further really kind of, you know, comes to light when you look at like what we're next going to talk about. Like, okay, like the caterer example, like let's say you want to do infused foods, you know, and even if you do waivers and everyone agrees they do in fact want cannabis, you know, this business or commercial purpose is still engaged in providing cannabis without the requirements of licensure. If you're a bar and you want to do, you know, marijuana infused food or beverage, if you're a restaurant, marijuana infused food and beverage, that's clearly the sale of product infused with marijuana. To sell marijuana to a consumer, you need a marijuana retailer license, or you need a type of license that would be, you know, of the type Lara can create licensure for in the future. So to do so prematurely means that you're putting your business in the position of engaging in conduct that hasn't been legalized effectively. Now, the penalties have been reduced in some situations, but that doesn't mean you can do it, and there will potentially be significant consequence for you if you do. Now, what that consequence is going to be probably depends on the facts and circumstances and how long you've been doing it and if there was damage created. And, you know, there might be people who do it and enforcement is not the same as liability, and maybe they'll never be enforced against. But nothing in the RTMA says that a business can engage in this conduct without a license.
Mm-hmm. And so let's use that framework that we went to before where it's, you know, different hats. So if I'm an individual, as far as infused food or beverages, if I want to make something at home, if I want to, you know, rudimentarily, kind of crudely extract THC using just regular, you know, some kind of alcohol and put it into some drink, is that something I'm able to do?
Definitely.
All right. Well, what if I am then marketing that and as a home occupation, it's almost a home brew, but I'm trying to sell it outside of my basement?
The same way that I can't brew beer in my basement and sell 6-packs to my friends without a liquor license, I cannot engage in the sale of marijuana-infused products or services without a license.
And I think, too, that kind of transitions into actual liquor licensed establishments. There was a Public Act 346 of 2018 that was actually enacted prior to Prop 1, where the legislature said, if this passes, we don't want to have marijuana-infused alcoholic drinks, wine, spirits, beers, beverages like that. So any type of location and actual commercial facility that has a liquor license is absolutely prohibited from selling marijuana-infused alcohol products. A little bit different if you're at the home and you're kind of mixing and doing some of that at your own, you know, as an individual with your individual hat on, not putting yourself out there to be a business person or an actual existing business, and certainly not with a liquor license. That would be 100%.
And again, it's not as black and white as you know, there's going to be situations where it's going to be hard to say where the line's going to be drawn. Like if I were to be a chef and I invite friends over and I cook for them, you know, as long as everyone's an adult, probably okay. What happens when everyone's bringing ingredients for me? Probably okay. But if everyone comes and throws me $50, we're in a gray area. One to be very cautious about if you are involved in that transaction, because what's the money for? Are you paying for your meal? Well, the meal includes cannabis, and and again, we're in uncharted territory. Our jobs as attorneys is to identify and inform of risk, and there's certainly risk there. Mm-hmm. Now, we're not talking about felony conduct anymore, but we're still talking about criminal liability. Mm-hmm.
Yeah, and that's a good point too, because if I'm a chef and I say, it's one thing to say, hey, I'm just a chef, these are all my buddies and my close friends, and I'm just going to whip them up a good dinner and have some cannabis-infused products, if they're all adults and everyone knows what I'm doing. It's another thing to say, if you came to me and said, hey, I have a special event I'd like you to cater, and it's, we're charging $100 and it's in a private event, but I'm still charging for this. It's another whole thing where if you rent out a space and you say, hey, tickets are $50, I'm going to be making cannabis food. And so at what point are you saying I'm giving you cannabis for money?
Right.
So there's also those considerations that you have to keep in mind that haven't been answered yet. And on top of that, there's, I think, the extra added layer of social host kind of, landowner liability when you're also doing that especially if you do it in a wedding venue. Even if they did allow it to happen, they're going to be concerned about their exposure. Right. If they're insured for certain things or have a license in and of their own self, then they're also going to be extra concerned. So there's different degrees of potentially stepping over that line, and hundreds, if not an infinite amount of different scenarios we could go over that may or may not be considered within the law and rules.
Right, and that kind of relates to the last type of category of gray market business idea that we always hear about, which is the idea of a social club. So, you know, again, this one's difficult as well. It involves, well, what truly is public and not public. You know, you can engage in the consumption of marijuana in private. You don't necessarily have to do so in your own home. You can do it in other places. But when you do so, it's not for commercial purposes. So what happens if a group of friends want to start a club, and that club we happen to consume cannabis? Well, it's going to be very important to decide, okay, the location where you gather, are you allowed to be there? Does the landlord or owner consent to that conduct? And then our problem is it public? Because a gathering that's promoted, seeking membership and things, it might be not as open to the public as walking in and out of a grocery store, but you know, it might still be considered public. You know, you can engage in the private consumption of marijuana with your friends, but not the public consumption. And you know, a social group like a fraternal organization or I don't know, just a social networking event. You know, if that is in public and not public, you know, not without restriction, like maybe you need to, you know, check in at the door, maybe there's some hoops to jump through, but it's not as private as it could be to have us be in a position to tell you, yes, you definitely can do that. Mm-hmm. You know, if you're in that gray area, you're in a case of first interpretation. You know, and marijuana laws have been fairly strictly enforced in the last several decades, and you need to be very cautious about the risk that's putting you in.
And also, too, just to go off of that, again, there's some social host considerations, because if I'm owning a social club and that serves cannabis and people are under the influence or consuming it, then who's to say I'm allowed to let them continue or allowed to let them drive home when I know, right, kind of similar to the social host liability for alcohol. If you're serving drinks and you know that the person's intoxicated and allow that to happen, you could potentially be liable for things. And that's another question for anyone who's thinking of opening up a social use club in terms of your patrons and in terms of how potentially impaired they might get. You know, they could drive home, they could have a bunch of dabs and a bunch of blunts, drive home, kill someone, and then potentially, you know, could turn into a lot of problems. And so these are all just kind of considerations, and we like to amplify it using worst case scenarios just to kind of hammer the point.
To illustrate the reasoning, whether you agree with it or not, whether we agree with it or not, it still is in place, and it's in place for a reason, and it may be a good reason, it might not be a reason, but it's one you should be aware of. And really just to kind of put a cap on it, you know, we had a black market, we now have a legal market we are in the process of creating. But what we are is transitioning from that black market to that legal market, and that's why we call it a gray market. There's going to be conduct that we might want to be concerned about engaging in today that we might, as this all starts to continue to be fleshed out and mature, recognize in a few months from now that there's no risk to there. You know, it was maybe being overly cautious. But, you know, we are trying to capture as much of that black market in a legal system as we can. And that's part of why these licenses are flexible. You know, we start with the licenses Michigan decided were most important: manufacturing licenses, point of sale licenses, testing and transportation licenses. And then we focus on capturing other parts of what was once a black market and put that into the licensing system too. Social consumption licenses, event licenses, you know, things of that nature. And it's Michigan's incentive to capture as much of that market in a licensed commercial industry as possible, because then we can control it for safety. We can tax it just like we tax everything else, and we can make sure that the system is safe for consumers, it's fair for stakeholders and operators, and continues to foster what is a quickly evolving industry. But, you know, until the state of Michigan has an opportunity to put the tools in place to capture that market, we transition. And you don't want to be the one who gets caught up in that transition and held out as an example of people who are impatient to do this the way that the system's designed it to be. And can the system be improved? Of course. Will those regulations need to be improved? Almost certainly. That's part of the process. So if these are types of conduct that you want to have your business engage in, the appropriate mechanism is to continue talking to the rule makers, continue talking both to the local officials where you want to engage in this business, to the state, to the Bureau of Marijuana Regulation, so that we can continue to foster this industry in a safe way, both for consumers, but also for you in operating your business.
I just think it's too high of a risk to do something without approval, especially in a gray area. If you look at other jurisdictions in other states with certain operators that might have been trying to take advantage of certain loopholes, not all the time, but sometimes it results in serious consequences that you'd never think you'd want to get in initially, and you'd never think it could get that far. But with certain loopholes like that and regulatory violations that could turn into charges if it's egregious, I think it's better to be safe than sorry. Wait and hold off on what you want to do until you're absolutely sure that it's legal and falls within the law and rules.
Definitely.
So
we were also going to, it's a very similar conversation. We were also going to march through CBD products. I think we're kind of running out of time here. But just to put a pin in it, rules and regulations for CBD are evolving as well. Just as recently, the 2018 Farm Bill at the federal level created a system where those products can be legal under federal law. Michigan's passing new House bills, House Bill 6330, creating a system where those types of businesses that can engage in a commercial aspect of processing, cultivating, selling these types of products in our state, but are designed and now in place. But what we need for that, the same as what we need for the RTMA, is rules, regulations, and a licensing process. And individuals that attempt to engage in, that industry, CBD specifically, run the risk of stepping outside the bounds or being premature to market in a way that could create risk for your business. You can go into a grocery store, any health food store in Michigan right now, and probably find CBD products. That doesn't mean there's no risk to the point of sale for selling those products. And it's an unclear system right now, and it's one that's quickly being defined.
And it's one we can definitely go into a little bit more in the future.
Probably will.
Definitely worth another maybe separate episode. But with the federal legalization of it comes more laws that intersect with hemp and CBD. And so because of the federal illegality with cannabis, there's really no regulations that have to be followed under the FDA for the Food and Drug Act because it's federally illegal. So they don't care. They just say it's illegal. We don't need to make regulations for these types of products. However, for CBD and hemp now that, at least at the federal level, hemp and derivatives are fully legal at the federal level, now you have to deal with the FDA, with all the different countless federal acts that also apply to every other single legal commodity in the United States.
As both cannabis and cannabis derivatives, CBD, everything else continues to become more and more legal, they're going to continue to be treated like we treat all other substances that are legal for consumers. When you buy a brownie or a granola bar, nutritional data is there. There's rules about what needs to be displayed. There's rules about if the ingredients and products are safe. CBD is going to have to go through similar situations. If you're a coffee shop putting CBD into your products, I have no problem with that. Nick certainly probably doesn't. People want that, but that doesn't mean there's not health concerns. That doesn't mean there's not rules and regulations that are unintentionally being ignored in the excitement of taking advantage of this green wave that we're creating here in Michigan. In order to put any ingredient in a product and then serve that product to a consumer, there's health concerns to have. And it's nothing against CBD. I think CBD is a wonderful ingredient, a wonderful product, but the same reason you can't just put vanilla flavoring in something without making sure that product is safe. The same logic's going to be applying. So before you go out there, as a coffee shop or a restaurant, putting CBD into something, just recognize there's risk there that you're probably not appreciating.
Yeah, because it's one thing to know that 100% it is CBD in exactly the way, shape, and form that you intended on buying. It's another thing with all the rest of the things you're mixing it with and what concentration of that alcohol might affect it a certain different way. And it's those types of things that you'd want to watch out for if you're just dropping some CBD in a mixed drink and marketing it to the public, because that's certainly something you wouldn't want to risk your liquor license for. Yep. You wouldn't want to risk any other kind of license in the future.
You don't want to have those products be you don't want to be told by the health department you can't sell them and have a stock of products you spent money on unable to be used. That could be a hit to your bottom line. So just like on the marijuana side of things, it's a little premature to rush out there and create a business recognizing that licensure is going to be required. I would highly recommend businesses contemplating engaging in using CBD to patiently wait for those regulations to create a safe industry for you. Not because I don't want them. I would love to go to a coffee shop and have my latte infused with CBD. I can't wait for the day that's possible. Just recognize, in order for it to be done across the board in a safe and legal way, we got to let the system play out. Mm-hmm. So, and continue to encourage our lawmakers and regulators to do that efficiently. No one's saying just wait and hope it happens. Like that motivation, instead of being put into a business that's creating risk for you, should be, I can't wait for my business to do this. Please make it happen, regulators. So I think we'll wrap it up there. Nick and I can probably talk another 2 hours about all this. So thank you for joining us this Friday afternoon, and we look forward to talking to you next week. So for Travis Copenhaver,
Nicholas Galendez.
Thanks again, guys.